I think we're going to go ahead and start. It's 1 o'clock and everybody's time is very valuable. Thank you all again for signing up. We have an extraordinary number of members on this call, and I want to thank you again. This is the quote unquote why you are a member. And if there's anybody on there that's not a member or that talks to restaurateurs that are non-members, the value of your membership in the last 4 weeks has been incredible. So I don't take that lightly. And I know, especially in these times, we started last week with a webinar just sort of on what the association's response has been since the shutdowns. And so many of you are asking for support and help from sort of an HR and a legal perspective. And for those of you who attend our annual Forward conference for the last 10 years, know the incredible value of hearing from both Dena and Gary from Saul Ewing and their legal expertise. We're in uncharted waters, so we don't have all the answers. And so many of you are searching for those answers, and the number of questions that came over. Some of what we are doing today, we can offer and advise you for free, but there's going to be some questions and some work that both Dena and Gary can't do for free, and we understand that. So as we navigate these uncharted times, I'm going to give the plug to them as far as hiring Saul Ewing. I think they're the damn best, and they work with us, and I'm proud to call them my colleagues. So I know they want to open up with some things, and then I'll get to the questions and answers after, in a little bit. So again, thank you. And I'm going to turn it over, I think, to you, Dena, first, right?
Yep, thank you. So good afternoon, everybody. We're really happy to be here today. I know that this has been a trying time for all of you, and it's our pleasure to give you some information about the Families First Coronavirus Response Act. It has been a very interesting time on the legal side to navigate all of these laws that are coming out and are changing very rapidly as well. So Gary and I, with our team, have been meeting every day to try to understand these laws, and are pleased that Carrie invited us to give you some information. I know we have a lot of questions, but we thought it would be good to start just with an understanding of these laws, to give you some information about what they are. And we're really going to focus today on the FFCRA, which is the Emergency Paid Sick Leave and the Expanded Family Medical Leave. I know that a lot of you have questions about the CARES Act and the payroll protection loans. We're really not going to do much on that because that's in and of itself a 184-page law that was passed. We can tell you a little bit. I know there were some questions about some of those, and if we can answer them today, we will, but we really advise you to get some legal and tax advice on those laws if you are seeking on those loans if you are seeking to get them. So I'm going to start. Gary, I don't know if you want to say anything before I continue.
Let me just pile on to what Dena said. Those of you who are on the phone today that are still operating are better off than many businesses in this country, even though it doesn't seem like it. By virtue of the essential business exception in most of the states, businesses that are in the restaurant industry are able to remain open to some extent, although it certainly is not like it was before. So while there are colleagues that you have in businesses, maybe even next door to you, who are shut down, you are open. Being open does present its own set of challenges. But I will tell you, there is no better person who knows more about the restaurant industry on a legal perspective than my colleague, Dena Calo. I am here just to, I'm carrying her groceries, so to speak, when it comes to this area. She knows more about this than anybody that I know, and I'm just honored that we're on the phone with you today. And thank you to Carrie and the entire organization and Alex for letting us join today. So Dena, why don't we take it with sort of just an overview, I think, of the FFCRA. And as you said, Carrie's got a lot of great questions, which we will try and answer on the phone for you today. If there's follow-up that needs to be done, we'll certainly make ourselves available for that too as well. So Dena, take it away.
Thank you. So, you know, I think as everybody has heard, as this law was evolving, the FFCRA applies to employers with under 500 employees. And one of the tricky things about this law, if you have under 50 employees, is that a piece of this law applies to you and a piece of the law may apply to you if you don't fall into one of the exemptions. So I'll explain that a little bit. So there are two specific laws here. There's the emergency paid sick leave law, and there is the extended family leave law. And I want to just talk about the family leave law first, because it really only applies in one particular situation, which is if there is a child care, if the individual is caring for a child whose school or place of care is closed due to COVID-19 related reasons, and there is no other individual to care for the child. So that's where the extended family leave comes in. The first 2 weeks of that are also covered by the emergency paid sick leave law. Okay, so it gets a little confusing. But so where you have enhanced family medical leave, that piece of the law, for those of you who are under 50 employees, you may be exempt. There is that small business exemption applies if, in fact, you can demonstrate that you would suffer some significant financial difficulty if, in fact, if, in fact, you were forced to comply with that law. Okay, and we're going to go into this a little bit further, but I wanted to give you the overview. For the paid sick leave law, no matter how many employees you have, up to 500, you are required to comply, okay? That piece of the law requires your company to pay an individual up to 10 days of this sick leave if the individual themselves is sick based on a COVID-19 reason, has been advised by a healthcare provider to self-quarantine, is caring for somebody who is subject to self-quarantine because of COVID-19, is experiencing symptoms but hasn't yet gotten a medical diagnosis but is seeking one. And so for all of those reasons, the individual has 10 days or can get 10 days of this emergency paid sick leave. Okay, so ultimately there are these 2 different sets of rules, one for anybody under 500 and one for those under 50. So ultimately, I keep getting, I'm sorry, I got a little distracted. I keep getting questions popping up. Ultimately, I think what we need to do is figure out kind of where you fall and what applies to you. Now, luckily, and I don't know if everybody has seen it, the Department of Labor has put out a poster that runs through in one page these employee rights and what they are, and it lays them out. So the good news is that you can find that poster on the DOL website. It lays out the reasons. It lays out who's an eligible employee. And for the sick leave law, everybody's eligible. For the family leave, this child care portion, if the employee's been with you for 30 days or more, they are eligible, okay? But that's a lot of stuff, right? It's a lot of information that we're throwing out there. And that's why this one-page sheet that the DOL has put out is very helpful for you to take a look at, because it's all there, it's on one page. And by the way, if you're still operating, your employees are required to get that, and it's required to be posted in the workplace. Gary, it looks like you're itching to say something, are you?
I was just going to say, yeah, no, Dena, what I wanted to say is, and can you just clarify for our audience that the FFCRA protection, you just did it at the end, is for companies that are still operating, right?
That's
So there
correct.
may be some of you on the phone who are not operating as of right now, and are just curious as to what's going on in the industry. The FFCRA applies, number one is employees there needs to be work available for those employees. And in the restaurant business, of course, people are not working remotely. So put that aside. So for example, if there are employees that are already furloughed or already laid off, these protections regarding paid sick leave and the paid family medical leave, really, that's not the focus. The focus is on active employees. Correct, Dena?
That's absolutely correct. So that was a big question initially, was whether if you had employees that you had furloughed, were those employees entitled to get these benefits? And the answer is no. The regulations and the FAQs that came out were very clear that it's only active employees who are entitled to get these benefits. And for those employees who are getting work, right, who have work available to them. So that's a huge distinction that we are required to make. And then the other issue is, how do we count employees? Because you may have had, 75 employees or 150 employees, and now you only have 5. At what point do we count employees? That's a very difficult question, and one that I would tell you that you should be seeking legal advice on a case-by-case basis. But generally, the day that you count is the day that the person is seeking or requests the leave. But that is definitely a very specific, factual question that you're going to need to get some legal advice on a case-by-case analysis.
And the other thing, and maybe it'll come up in some of the questions, but it seems natural to talk about it right now, is sort of the financial ramifications or implications of if you are required to provide emergency paid sick leave. And you probably have read about this. There are tax credits that are available to you. This is something you're going to talk to your financial planner or your accountant about, such that what the government has done is to say, if you're going to provide those benefits, that there is an ability to, when you do your quarterly payments, that you're able to hold back cash that compensates you for that. It really is working with your accountants on that to make sure that you have that information. And last but not least, Dena did mention the under 50 exemption, which is the idea is that if you're simply under 50 and you can demonstrate that you cannot afford to do this, there may be the exemption. But am I correct, Deans, that as of right now, neither the DOL nor the IRS has yet put out guidance on how you qualify for that exemption?
That's right, although we've been getting some of the FAQs that talk about things like, there are 3 specific things that have come out of, I don't remember which document, but I do have 3 specific things. One is at the expense of providing the child care related expenses would result in your expenses and financial obligations exceeding revenue and cause you to cease operating at a minimal capacity. The second one is the absence of the employees requesting leave would cause a substantial risk to your financial health and operations. And the third is, if providing the leave to those requesting it would prevent you from operating at a minimal capacity because it would cause the lack of able, willing, and qualified employees to be available to perform services. So there are a few examples, and if anybody needs to speak with us after this, I can provide those to you. We can provide those to you. But more guidance on this is going to come out. What I would say again is your accountant is probably the best person to talk to, or your legal advisor about these, because this is documentation that you're going to need in the event that an agency, a government comes and does an audit and says, hey, why didn't you provide this family leave for an individual who asked for it? You're going to need to have documented why you were not providing it. I realize that one, yeah.
Can I ask a question really quick, because it's coming over?
Sure.
There is a question about, does this new law sunset at any time, or is this from now forward, number one? And number two, when you talk about 500 employees and under 50, how are you grouping employees? Is it under, say, one individual location, or is it like healthcare reform across the entire company?
So at least from the sunset provision, the FFCRA expires, at least currently, on December 31, 2020. There is some thought that there are those in Congress who would like to extend certain portions of this, because there's been an effort over the years for family leave to become paid family leave. But for right now, it does expire at 2020. With regard to the question of 500 employees, there are two tests that the government is applying. One is known as the joint employer test. And so regardless if you have multiple corporations, if the corporations are generally controlled by the same management group, from a financial perspective, there's shared resources, et cetera, and also what's known as the integrated enterprise test, where you've got common HR, common policies, et cetera. That's how they will group them together for purposes of determining whether or not they qualify for being under 500.
And I realize we didn't actually talk about amounts, and I think that's important, because I know there were some questions about how are we going to afford this. So let's talk about what those amounts are. For the emergency paid sick leave for individuals who actually come down with COVID or have been exposed and are now isolated for 14 days or are caring for somebody who is, the individual is entitled to receive up to $511 a day, or their own salary, right, whichever is lower, with a maximum for the 10 days of $5,110. That amount cannot be offset by their own PTO or anything like that. That's a separate amount, and we cannot require them to take any time off that they have already accrued. For an individual who is taking either the emergency paid sick leave or the enhanced family medical leave to care for a child whose school is closed or who does not have any child care option because of COVID-19, the amount is 2/3 of their salary up to $200 a day, and $2,000 total for the first 10-day period. And then remember, for family leave, this is an FMLA obligation. It goes for 10 or 12 weeks, although the first 2 weeks is considered unpaid. So that is up to, it could be a $12,000 total. So that's for those companies who are more than the 50 and not less than the 50 and not exempt, or up to 500. That's a much greater amount. Once we get through that first 2 weeks for the emergency paid sick time, we can talk about the substitution of PTO time that they have already accrued. And I think with that, we can start moving to the questions, Carrie.
Yeah, there's just so much happening that our members have questions on. So let me start now. So the first question I want to ask from a member, if we still have employees working for us, what sorts of legal documents or disclaimers, if any, should we have them review and sign in regards to working during the COVID-19 pandemic?
So as far as we're aware, there really are not, other than posting this employee rights document, right? The FFCRA document. And because restaurants aren't typically going to have teleworkers, although I understand maybe there are some corporate employees who could be teleworking, and therefore you may need to email or send this poster to them. There are no other documents that I am aware of that we need to, or disclaimers or anything like that, that we need to have employees sign off on when they come to work. You know, we have, when we'll talk about certain things that we may be should be considering doing along the lines of personal protective equipment or other lesser things. I mean, I don't know that we certainly need the specialized masks that healthcare users are using, but you know, there may be things that we would consider or should be considering, but those are not disclaimers or things of that nature. The only thing that I'm aware of that we are required to have employees review at this time is the Department of Labor employee rights document.
You know, go ahead, Gary.
I was just going to add on to what Dena said. There is no requirement that we are aware of. However, there are some employers that are in terms of their communication with their employees, and actually some employers are requiring employees to fill these out on a regular basis. You are permitted under the EEOC guidelines to ask employees whether or not they are experiencing symptoms, COVID-related symptoms,
Absolutely.
whether or not they've traveled outside the state, or they are in contact with somebody who either is tested positive or may be symptomatic for it. And some employers are doing that through a questionnaire that they're having employees fill out. So, but to Dena's point, there's not the situation where there's a disclaimer where the employees are releasing the employer from liability by coming to work, so to speak. You know, there's some guidance out there now about if an employee tests positive or has COVID-related symptoms, are they going to be able to file a workers' compensation claim? Claiming, and there's going to be a big battle. We see that looming down the road as to whether or not somebody actually potentially contracted COVID at work or not. We think that's going to be a whole cottage industry in the workers' compensation area. But there is no sort of disclaimer where you're getting sort of a release where the employee is releasing the employer. It probably wouldn't be valid anyway.
Yeah, there's a lot of questions coming over, you know, by signing something because, you know, they're offering people work. But, you know, if they come down with coronavirus and they say, I got sick at work, you know, can they flip that? They're asking their employers right now to work because they want to work and they need the money, but it benefits them. But if they get sick, can they flip it on the restaurant business and say, you know, we got it from work?
Well,
yes.
That's the signing of things I think is important. The liability is important to talk about, I think, or are we in the wild, wild west right now?
I mean, at the end of the day, we always have to remember that workers' comp law says if you can demonstrate that you were injured at work, it's workers' comp, there's workers' comp liability, right? And there's nothing that we can do, even when you sign a formal release after a lawsuit or something like that, we can never release a work-related injury. Unless you're in front of a workers' comp judge, that would not be valid. And so we cannot say to somebody when they come into work, hey, in order to work here, you have to release us from any injury that you might be exposed to, including any illness or disease that you might be exposed to. That would be invalid. We can't do that. It would also be inappropriate if somebody said, hey, I think it's you're not doing what you need to do to keep us safe in the workplace. And you said, well, you're fired, so get out of here. I don't want you rabble rousing in the workplace. That would be retaliatory. We can't really do that either, right? So the only thing we can do is try to keep our morale up by creating as safe and comfortable work environment as possible, following CDC guidelines. And that's why, one of the things that we've been talking about as a group in the law firm is this idea of providing things like face coverings to employees. In sister states, New Jersey and New York this week, the governors issued executive orders requiring employers to provide any employee with those coverings if they're engaging with the public. Actually, in New Jersey, any employee needs to be provided it. In New York, they have to be provided it if they engage with the public. And that's an employer obligation. And so the question really is, in sister states, surrounding states, should we as employers start thinking ahead? Number one, are we going to be required to do it? But number two, should we be doing it to make our employees as comfortable as possible coming into work, ensuring that they feel safe? Because what I'm dealing with now multiple times on a daily basis are essential employers saying to me, I have employees who don't want to work. And how do I deal with that? They don't feel safe. They feel safer at home, or their spouses and children don't want them coming in anymore. And so how do we deal with that? And I think the only way to deal with that, to ensure that we can continue operating and continue revenue coming in, is to make our employees feel as safe as possible in the workplace. And one of the ways to do that is to ensure that we are providing the most sanitary conditions, the safest conditions that we possibly can. I mean, we can't cover everything. That would be impossible. But what we can do is provide them equipment, try to ensure that our customers are, as contactless as possible, right? When, if they order their, we're trying to ensure that they're doing payment over the phone, things of that nature. So I think those are the best ways, social distancing if possible, things like that.
Let me just reiterate, Carrie, on your liability question.
Okay.
Because this is why businesses have workers' compensation. Workers' compensation is a no-fault statute, basically. If somebody is injured in the workplace, that's where workers' comp kicks in. That's why employers pay for it. The difference, of course, here is if somebody slices their hand, that's a workplace injury, and you can deal with that. COVID is going to be different, and I think there's going to be, again, big battles between the insurance carriers and the employees, potentially, as to whether or not it's a workers' comp claim or not. I think we feel pretty comfortable that if it's determined that it's not a workers' comp injury, it's going to be determined because it didn't occur in the workplace. And therefore, there should not be any liability to the employer under those circumstances.
Thank you. And then, we have a lot of members on the border right now, and the governor's, under his orders, he's really trying to restrict people from coming across borders, even from Pennsylvania down or at the beach area. And I have a question from a member that says, with our new process of notifying in advance, we have received more and more non-Delaware residents arguing Governor Carney's order restricting out-of-state visitors is unconstitutional. We have been turning away the business, but the disputes are getting more frequent and more aggressive. As a business, I want to make sure I am doing the right thing by saying no, but are we opening ourselves up for more litigation?
So I will tell you that my own personal view is that the attacks on various governors on restricting travel one way or another being unconstitutional, I think are likely going to fail at the end of the day. There was an attempt yesterday, I think it was, maybe it was in Pennsylvania, to argue that the governor of Pennsylvania's orders were unconstitutional. That got struck down. So I don't think these constitutional arguments in this environment, I think the executive of each state has that ability. And, you know, the question is really what these travel bans are meant to do. There is not a situation, to my knowledge, at least anywhere on the East Coast yet, where somebody has been told you are not allowed to leave your house. You are quarantined, you are officially quarantined and cannot leave your house. There are a variety of businesses that are open for essential services, and I suspect that some of the businesses in Delaware that are essential services have residents from Maryland and New Jersey and Pennsylvania who need to travel to those businesses. I guess the different question is whether or not you have a resident of Maryland who wants to come into Delaware to pick up a takeout order of some sort. And, you know, you guys are not the police, right? I mean, that's the enforcement really isn't against you. I'd be curious to hear what Dena has to say about this, but it's the state government and the officials in the state that have that authority. Now, might someone be pulled over by a police officer, Delaware or state trooper, and said, "Why are you traveling into Delaware? Why are you here?" And they might, and they run that risk, but I don't think the risk necessarily runs to the employer to be the police in determining whether or not people are allowed to come into the state or not. Dena?
I agree with that. I mean, it's not your job as a business owner to enforce the laws of the state. I think it's the job of the state to enforce its own laws, right? So, you know, at the end of the day, if you're a restaurant and somebody wants to place an order with you, it's not your role to check IDs, right? To say, hey, now, if you're selling alcohol, is that a different issue? You know, I think perhaps it might be. We'd have to check the ABC laws, which I have not done prior to this call. But with just the sale of food, I think this was, you know, the services, things like that, that's not something that I would be concerned about.
And I think, and the reading of the executive order, by the way, there's a conflict in part of it from what I think we saw, which is, and you guys, you know, you may well have studied it a lot more than we have, but there's one provision in the executive order on travel that says, if you come into Delaware, you're supposed to self-quarantine for 14 days. And that means maybe even staying in a hotel and whatever it might be. But then it says, if you're coming into Delaware with the intent to go back to your other state, the quarantine part doesn't apply. So that would seem to suggest, what does that really mean? And why is somebody coming into Delaware? And what is the purpose of them coming into Delaware? And where that fine line is, I didn't see a distinction so much in that executive order that tried to explain how those two things work. I think maybe it's the idea is that if you're returning to Delaware from having been out of state for some time and you either live here or you're here for business for an extended time period, you're supposed to self-quarantine as opposed to either coming across the border briefly with the intent to go right back. Again, I think that's a dichotomy that I'm not sure has a great answer.
Okay, most of the questions, I just wanted to get some of those out of the way. I want to go back to sort of the paid sick leave because there's a lot of questions around that. And one is around the hardship that you mentioned for employees of, I think, 50 or under. How effective will the business hardship loophole be to prevent use of this policy? Or will one be open to regulatory punishment of an employment claim? What are you seeing?
Well, I think there's still a correct me if I'm wrong, Dena, the regulations talked about there being some safe harbor for 30 days that they weren't going to be enforcing that.
For 30 days, but I think that's, you know, that's going to be over soon, May 1st.
It's going to be, correct. It's going to be over very, very soon. I think there's look, the practical answer is, and this is sort of shorthanded. If you are simply going to, it's almost like if you're going to go out of business because you can't afford to pay for employees to get this paid sick leave, I think it's sort of that standard. And the idea is because you've got these tax credits available to you, it may be a cash flow issue, which is one thing, but literally if you can do it, recognizing that you're going to get the tax credit for it, saying that you just don't want to do it or there's a hardship to it, I think it's going to be a harder test than that. It really does. And Carrie, as of right now, there's no specific guidance on tells you how do you fall within this box. So we have a number of clients that are doing it. The real question is also how often is it going to be triggered for you? Remember, there's 6 specific criteria for whether or not you qualify to get this paid sick leave. And you know, it will happen from time to time. Is it going to be every employee that you've got that has COVID-related issues, that they've got a doctor's note certifying on it? We certainly hope not. But from what we can tell right now, I think the standard's going to be fairly high or low, depending on how one looks at it, just in terms of being able to say, we will basically go out of business if we're required to pay 2 weeks of sick leave.
And remember, the cap on that well, it'll be, the sick leave is $5,100, but at the same time, you get to keep back federal income tax that you would have paid. And so at the end of the day, you should be getting a dollar for dollar credit on that you're actually keeping, otherwise money that you would have otherwise paid to the government. You're not waiting months to get that back from the government. You're actually retaining it. And so, you know, I do think it's going to be a very high standard to meet.
Well, you know,
and you're not going to be at that. You're also not going to be at that most of your employees aren't going to be anywhere close to $510 a day.
That's right.
I understand, but remember, if the policy is subsidized via tax credits, what if the business doesn't make enough profit to use up the tax credits in a year? You know, nobody's—
It's not profit. No.
No, it's not profit.
This is different. This is different. This is why people should talk to their accountant. It's not that kind of tax credit. The tax credit is when employers on a quarterly basis have to deposit federal withholdings that they've taken out of the employee's paycheck, and also the FICA or whatever it might be, and those contributions. That's what the employer gets to hold back. So by way of example, and this is why people should speak to their accountant. If an employee was paid $100, and out of that $100, the employer took out $20 for federal withholding, it's still going to show that the employee had $20 of federal withholding taken out. But when the time comes, if that employer paid that employee sick leave, the employer is going to be able to hold back that $20 that was withheld from the employee. The employee is still getting credit for the fact that they had deductions, but the employer holds on to the cash. So It's not a profit analysis, Terry. It really is dealing, or Carrie, it's dealing with the question of how you're making your quarterly your quarterly payments.
Okay, you guys, there's some noise on the call, so make sure everybody's on mute as well. Sorry, that's just something Alexa just came in on. Okay, that's good. There's just, and we're correct, right? That the DOL has not published the guidance on this yet. And if it hasn't, when do you think it's going to be expected?
On what? The exemption?
EPSL, EFMLA request form.
Oh, on the request? No, there's no request form that's been issued yet.
And we don't know when it's coming, or what? You heard anything?
No.
Okay. So here's another question. If an employee requires time off due to a family member's COVID positive test and exhausts the 10-day benefit, then he or she tests positive themselves, requiring more time out of work, can they request more time under EPSL, or would that then be an EFMLA, FMLA request?
Okay, so an employee may only get the 10 days under the employee paid sick leave once. So assuming that the employee takes the leave for a family member's COVID-related illness, and then later they get COVID, they are not entitled to take it again. And remember, the extended family leave is only related to childcare. However, there may be an issue, and family medical leave, they may qualify for, but generally it's not paid.
Okay. All right, there's some more questions as it relates to, this is all sort of HR related and unemployment now. Are salaried employees that are furloughed allowed to work a reduced number of hours for a reduced amount of pay while collecting unemployment? What are the particular details that need to be followed to get full unemployment benefits for employees that we may be able to still get limited hours to?
So if you're talking about exempt employees, people who fall within the exemption under the FLSA, which allows employers to pay employees, there are a couple of issues there. Under what's known as the salary basis test, employers are generally required to pay exempt employees the same amount of money each week, regardless of how many hours they work. So if they work 30 hours one week, they get paid the same if they're exempt. If they work 60 hours, they may be exempt. There is an ability to go to employees and frankly mandate it and say, and this has happened quite a bit, which is where employers are telling employees, we are cutting it's happened a couple of different ways. One way it's happened is we're doing an across the board 25% cut of your pay. You're going to continue to work on a full-time basis as an exempt employee, but we're going to go ahead and cut this, and there's some potential notice requirements in terms of the notification ahead of time. But that's one way that some employers are going about doing it. The other way that employers are going about doing it is they're also doing with a commensurate reduction in the amount of hours. So not only are we cutting back or whatever your compensation may be, instead of you working, an undetermined number of hours, you're only going to work 32 hours. I'm not sure for exempt employees that matters one way or another. What Dena and I have also seen during this time period, which may make sense for a lot of employers in your industry, given the fact that many managerial employees have now sort of crossed over and are doing what would otherwise be considered non-exempt work, is to consider during this period of time, whatever the COVID pandemic is until it lessens, to convert your your salaried exempt employees to hourly employees. And that way they get paid for the hours that they work. You don't have to worry about a 25% reduction or something along those lines. So that's what we have seen also, where because you can always have exempt employees be non-exempt and pay them by the hour. You can't always have it the other way around, right? So that's something that we have seen and recommended, because it is a way that employers can get better handle on costs and controls, and saying they know that this person who used to get paid $500 a week, regardless of how many hours, is now been converted to an employee that's earning $18 an hour or whatever it may be, and we're only going to make them work 20 hours, and you're able to control a little bit on ebb and flow and know exactly what you're envisioning there. Dena?
So I agree with everything that Gary said, and those are important distinctions to make when we're trying to manage our shifts on delivery and takeout, but we only are working with management employees or exempt employees, and we're trying to juggle our staff. On the question that Gary asked on unemployment, one of the things that is critical to understand if we're really worried about our employees is, well, if we have an employee who's furloughed and is getting some form of benefit, are we harming them by bringing them back and having them work to some degree? And the answer is, in Delaware, they are still entitled to some form of partial benefit if they are working, if they earn wages up to 50% of the weekly benefit. We are not, we are not going to profess to be unemployment experts, and you can certainly contact the Department of Labor directly as an employer But what we will tell you is there is an ability for your employees to get partial benefits if they work some of the week. I don't want to give you specific numbers because you need to make sure that you are working with your Department of Labor to know what those numbers are and what the weekly benefits are. So I don't want to give you concrete numbers, but I will tell you that partial benefits are permitted, and it looks like in Delaware it's up to 50% of the weekly benefit.
Yeah, we do know that. We're getting a lot of questions regarding unemployment and our workers. And then, you know, there are cases where, and it comes in the questions where workers are being asked to be laid off, right? Furlough me because I can make more sitting at home. But, you know, through carry out and whatever, there's work for them. So is there a process? Can actually a restaurant, we're concerned about our own unemployment rates, right, in the future. And how do you decline an unemployment benefit if in fact you have work for them, but they don't want to work? So are there legalities, are there ramifications against the owner about that? So what are your thoughts there?
So we've been dealing with this a ton in the last week to 10 days. So there's a few different issues you have to be careful of here. One is that the reason that the individual is requesting to be laid off or to not work is not a COVID-19 related reason, right? So that they're not in a high risk category. They haven't been diagnosed or been isolated because they've been exposed to COVID-19, right? So number one, what we're recommending is that you speak individually to the person and find out exactly what their rationale is for not wanting to come to work. Let's assume that we have an able-bodied individual. They are not high risk. They're not vulnerable. They have not been exposed. Their rationale at this point is, I don't want to expose my family. I don't have anyone who is high risk at home, right? I just don't feel safe and I don't want to come to work. In that circumstance, what we're recommending is we put a letter together that indicates exactly that. You've indicated to us that you are not interested or that you, you have indicated to us that you are, you would rather, because of, your own safety, you have decided that you don't want to come to work. We are recommending that you put in this letter that you, as the restaurant, are engaging in all of the precautions set forth by the CDC and your local health department, that you have work available, that the individual is choosing not to perform that work, that the individual does not fall within any of the categories set forth in the FFCRA, and that as a result, you are releasing them from employment. However, there's nothing, you are not making any guarantees about whether that individual will get unemployment benefits, and that you are going to provide the letter that you've set all this forth in to unemployment. It's our belief, although we can't make any guarantees, that a letter of that sort provided to unemployment that says that work is available, that there's no valid reason for the individual not to be coming into work, is likely to prevent the individual from getting unemployment, but we don't know that to be the case. We haven't seen those go through to fruition yet, but that's why we're putting it all in there, that you have a safe environment, that the work is available and those things, because we understand the issues that are facing employers. And we also understand that if you have this domino effect of employees saying, hey, I'm going to get more if I stay home than I will if I come to work, that you may have a workplace that has nobody coming to work anymore. So it is very important. Important.
And what we haven't seen yet, and it'll be interesting to see what comes out about it, is what is going to happen with the experience rating. Because, restaurants are essential businesses and they're open. You have all these businesses that are closed because they're not essential businesses, and all of those people are going to file for unemployment. And it'll be interesting to see if the government then turns around and starts slapping all these employers who can't be open because there's an executive order that your experience rating needs to go up. I don't believe that that is the intent of Congress. That's why part of the CARES Act and part of the FFCRA have so much money earmarked to support unemployment programs with this additional dollar. So I think there will be an intensive lobbying effort if it starts to come about that the experience that has happened as a result of COVID-19 is hopefully not going to be borne by the backs of employers who are either forced to lay people off and therefore the people get unemployment, or some of the circumstances even that when you are operating, you have people who are getting partial unemployment. But that's probably a soapbox speech more than it is anything legal right now.
Well, I can talk about that. And so for all of our members on the phone, you know, certainly all states are going to have to pay back their unemployment trust funds. So we sent a letter to the governor's office today, and it's been on our weekly calls with the governor, that we are asking for a freeze on increases in unemployment insurance rates, you know, because of exactly what Gary's saying. And, you know, I want to follow up on that a little bit, because as we start to see these PPP loans coming into our state and for our restaurants, you know, we see restaurants beginning to reach back out to employees to say they will be activating them back onto the payroll, you know, as with funds from payroll protection funds. But you know, restaurants are seeing several employees say, yeah, you know, I'm making more money on unemployment, so I don't want to come back. What is the responsibility to unemployment? Are we supposed to notify unemployment to tell them that employees have declined being put back on the payroll? This is a reality right now. And this is the fear of our industry, right? People aren't going to want to come back. So do you have anything to say, you know, about that and what we should do?
I mean, that is a great question. I think it goes to the whole issue about whether or not there was work available or not.
That's right.
I don't know, is the unemployment office still reaching out on a regular basis to find out, or what does the employee have to certify? I mean, that was part of one of the issues that came up about some of this under the COVID-19 pandemic for unemployment, which was that the notion that you didn't have to go out and search for work, which is normally what you have to do with unemployment, was being suspended in certain circumstances. I have to believe that as some time goes by, Carrie, and this is again speculative more than anything, as some time goes by and the states start to think about reopening, I think that the gates at the unemployment office are going to start to close more, and employees are going to have to verify that in fact there is no work available for them. And then, because if they do, and there is work available for them, and there's a reach out to the employer, I think the employees could be looking at some fraud claims coming down. So I think.
Yeah, the other thing, I'm sorry, Gary, I didn't mean to cut you off. I do think that when the PPP money comes in and offers are made back to their employees, that should be done in writing, right? You are being, you know, rehired, you know, your furlough has ended. We are offering you reinstatement. However we want to say it, that needs to be figured out by your legal advisors. But that needs to be done in writing, because if unemployment doesn't end now, I think what we're going to see is a reach out by unemployment back, where they say, hey, you know, you had, or reach out to the employers at any time during this period was work available. If it doesn't happen right now because they're totally inundated, it will happen in the future, I believe. And then they're going to go after these employees to get their money back. I think they will, because there's going to be such a dearth of money out there that the states are going to start coming back for their money. So we have to document now that work was available, payment was available, and that the employee refused. And then when the employee refuses, there needs to be a follow-up document. We offered it to you, you refused, there was work available, you know, there's no longer a position available for you, and we need to end the furlough, end the benefits, right? So I really do think we need to do the same.
Well, and on the converse side, we're getting questions, you know, now that they've sort of laid everybody off because of the pandemic, I'm getting a question, well, what happens if, right before the pandemic, we wanted to replace some employees. Maybe they weren't good anymore, and now we want to, because of poor performance, we wanted to terminate them. Are we going to have a problem if we don't bring them back? Is there anything we need to do or to protect ourselves from that? I mean, that can happen too. Is there a...
Here's what I think. Now, are we talking about employees, Terry, that were laid off, and so their employment is ended, or employees that are furloughed?
So say the business closed, right? So this is a catering company, so they're not even open for carry out. And before they were planning on a reorganization and replacing some of its management. What if they don't bring those people back or offer employment?
So I think
oh, go ahead, Gary. I'm sorry.
Okay, I'll start and Dena will fill in. So one of the things that, first of all, shame on them for not having dealt with the performance issue while the employees were still there. But putting that aside, remember that what still hasn't gone out of the way are the various discrimination laws that you do have. So if there's a legitimate business reason for why you are deciding not to bring somebody back, that's the same legitimate business reason that you would have had ultimately, perhaps, for terminating them. What you need to be careful about is that when you are bringing people back, and you want to use this as an opportunity to maybe purge your ranks of people that you were thinking about getting rid of at some point in time, just remember that you still have to look at things and making sure that you're not discriminating against women in favor of men, that you're not bringing back all of the younger workers, but anybody that's over 40, you're not bringing back. You're bringing back people who are white, but you're not bringing back people of color. So those same hiring issues that you think about for discrimination purposes are probably how you should be thinking about recall. Again, if there's a legitimate reason why you're not bringing somebody back, as long as you can document that and articulate it, ultimately, if somebody says, hey, you discriminated against me, you brought everybody back, but you didn't bring me back, and it's because I was older, etc., those are the same tests that you would be using as before. Dena?
I agree with everything Gary said. I just want to add that we see this a lot. Let's pre-COVID-19, somebody goes out on a disability leave or, need to be out for a period of time. And while they're out, you say, boy, I can run this place very well without this person. Their issues are coming to light. Why do we even have to bring them back? And, typically what our advice is in that situation is, where's the documentation, right? Do you have documentation of their performance issues? We need to look at that. And I'd much prefer to see you bring the individual back, even for a short period of time, because it's better from our perspective, from the legal perspective, to demonstrate we treated everybody fairly across the board right now. And believe me when I tell you, we've seen from experience, these performance issues are not going to go away, right? You're going to have those same issues. Let's demonstrate we treated everybody the same, right? And then ultimately, right, there was a performance issue that you can clear up in the couple of weeks after we brought them back. I think that's a cleaner way to do it, unless you have such significant documentation, like, look, we were going to meet tomorrow, right, and terminate, and I have all the documentation that was going to happen, but then tomorrow the governor closed all our facilities and, everything went astray because of COVID-19, so we couldn't do that. Then on the day we return, we would have done that anyway. So, I think there are some factual situations where you could say, hey, I'm not bringing this person back because they were about to be terminated anyway. But absent that, I think it's very risky to just not bring somebody back because, hey, they were a bad performer and I would have taken that action. Demonstrating that is very difficult if we don't have really clean, really extensive documentation.
And let me just add one thing back to that, which is you also have the practical aspects of it, which is if you're reopening your business, the likelihood that you are bringing back everybody at the same time in this environment is probably pretty low, because I don't know that you're going to get back to whatever normal was. So I will say, subject to everything that Dena said, I got no problem as a management lawyer saying, you bring back your best people first. So that's
as an overall concept. I think that's right? Like, let's look at, but even doing it that way, let's put together a plan as to what that means, right? So let's put together the best of the best and bring them in. But how do we evaluate who that is? I agree.
Okay, let me move on because we're at 2. So I just want to ask a couple more quick questions and regarding unemployment, and then I'll finish with the last question on insurance. But this is a really great question from a restaurateur that says, I have a chef who is at high risk cancer treatments, who takes public transportation, and I would prefer not to put him at risk. Do I have the right to request that he stay home?
Yeah, I think you do. I mean, there's nothing that tells an employer that, look, we think that you are, number one, high risk. And we talked about this a little bit. It's the same. The flip side of the question is, if he's high risk, can he claim that he's high risk? And if he had a doctor's note, could he fall within the Paid Sick Leave Act? I think an employer under these circumstances has the right to tell an employee, you are exposing yourselves to public transportation, and therefore we are concerned about you exposing our workplace to something that you may catch. So we're telling you that unless you either are coming to us directly, putting aside the high risk issue just because he's, a cancer survivor, I think the employer could say, we want you to stay out.
Are you paying him?
I don't know, but I'm assuming so.
Now, and also, well, one of the things I will say is, you have to make sure, though, that it's COVID-19 related, meaning you can't just treat somebody differently because they may have a disability, they might have cancer, because that could still expose you to liability under the American Disabilities Act,
Right.
that you're not reasonably accommodating this individual. And if your real concern is that they are taking public transportation, how can the employer accommodate that issue? If that's the primary concern, that they're taking public transportation to get to work, there are ways around that situation of telling the employee you can't take public transportation or whatever that may be. But those don't go out the window. But from a general standpoint, I think there's going to be a lot of leeway here a little bit, where employers are going to have some more flexibility under discrimination laws, particularly the ADA, but it's not going away. So I think you just have to be mindful of that you're treating that person, it's COVID related and not just because they have cancer.
Okay. I have to decline something. Hold on a second. I'm getting back on. It seems there's so many questions about employees and unemployment and will they come back to work. I do think it's important, when we did our webinar, and I'm sure most of you know that $600 benefit that the federal government is giving through unemployment insurance will end. It's authorized for up to 4 months, or when the governor lifts the state of emergency. So that's number one. But here's a question. As a way to minimize employees refusing to come back to work, should we send the employee a certified letter and send the same letter to the unemployment department as a means to force a cutoff of the employment benefits?
Well, look, I think the unemployment issue, first of all, not everybody is, as I understand it, is automatically getting that $600. I'm not an unemployment expert. I think the unemployment office is managing this, the best way that they can. I don't think employers should be that punitive. And, it's one thing, if employees don't want to come to work, then employees don't want to come to work. But I think the employees got to understand and recognize that at the end of that period of time, there may not be a job for them.
That's right.
And they might not come back, right? There may just not be a job for them. So I would, if the unemployment office is requiring you to verify or certify whether or not there's work available, that's one thing. But going ahead and sending out certified letters to the employee and then copying unemployment, I wouldn't do it.
Yeah, I agree. And when we open up, we're going to be in a different time period than we were 3 months ago. So
right.
I do agree. There's so many questions on that, but I'm going to stop that question. And I know our time is limited, and I'm going to ask one that restaurateurs are asking all over the country right now. We're addressing this in certain states, and as well as it's a national conversation. And Gary, you and I were on this late night one night with one of our restaurateurs. So here's the question. Do you think we have a legal case against our liability insurance to pay out business interruption claims? Would FEMA declaring a natural disaster force the carriers to pay out?
So I'm going to make a following statement. My law firm represents insurance companies, so I am not at liberty, nor is Dena at liberty, to even comment on this in terms of whether or not there's a cause of action or not. The only thing I can tell you, just observing the news, that there are some lawsuits that have now cropped up around the country where employers are challenging employee insurance companies' denials of coverage, claiming that the virus exclusion should not apply. So all I can tell you is just if you're interested in something like that, look into it locally. Speak to some lawyer who might be interested in suing insurance companies, but that's all I can say about that.
I do want to mention that I am following the legislation across the country. I believe New Jersey and Massachusetts both have introduced legislation to require that. I am hearing through my counterparts in those states that those pieces of legislation are not going anywhere at this time. So it is a conversation that they're having nationally. I know it's a big concern, but it's if something like that is going to happen, it's definitely not going to happen overnight. And that's all I can say about that at this time. So is there anything else? I mean, I have stacks of questions that I think we're going to look at. And for those of you who didn't get your specific question asked, we will forward that to Dena and Gary, and they will answer some of those simple questions that they can. And if it needs further guidance, then you have the ability to talk with them further. I guess, Dena, anything else from your end, sort of as a closing statement? And then Gary, I'm again grateful for you guys. You've been our the most popular reason to come to our Fast Forward events every year, because you give it straight. And every time I get off the phone or get done listening to you, it gives me more heartburn. But I guess that's the reason why you are my dear friends and colleagues. So is there anything else, Dena, from your end right now, and what you're hearing and what you think restaurateurs today should be thinking about moving forward?
I mean, one of the things we didn't really get to is what happens when we return, right? The return to work. And I think that that's what we should be hopefully what we should start thinking about, and what does that look like? And I do think we should be, let's keep our fingers crossed. Let's think about what that looks like as we move forward. It's not going to, I don't believe, I mean, as we have these calls every morning, and that's what we've started talking about. What does the return look like? And it's going to look different. I mean, the trends are temperature checks, right? Getting information on employees and potentially customers before they walk in our door. Whether that's an actual no contact thermometer, whether that, I mean, what is that going to look like, and how are we going to manage it? So, I mean, I think that we're likely going to have to engage in those discussions and really keep up to date in what the wave of restaurant life is going to look like in another month and 2 months. I think we all have to keep up to date on that, and we'll certainly be ready to help the industry as much as we can as we move through those processes.
I want to follow up a little bit with that, because for those on the call, I was invited to sit on the press conference the other day between the Northeast governors that have formed a working group to talk about moving back, reopening. And specifically, I was on the call with our governor in Delaware, but also New York, New Jersey, Connecticut, Pennsylvania, and Rhode Island. Many of you saw that, the results of that press conference on the news. And I do believe Delaware will be looking to see how New York and New Jersey open up. And Dena, you talked a little bit about New York and New Jersey now requiring masks. So we are going to put a document in front of the governor's office next week. We also have, again, a weekly call with him and his people, and we will have direct access to the people making sort of those decisions. So those are some of the things and the action items we'll be working on this coming week. And I don't know if you have anything to say, Dena, especially, or Gary, about what's happening in New Jersey and New York about those items, or if we're just in a wait and see right now.
So let me follow up what my good friend and colleague Dena talked about, and she mentioned it earlier today. And I'll tell you what I would do if I was a restaurant. And I fancy myself years ago. I thought I would be a great restaurateur. But one of the things that you think about from restaurants is image. And when the COVID-19 pandemic started a month ago, one of the questions that we were getting asked was, if our employees want to wear masks, do we have to let them? Because you were thinking about your image, right? You're a retail establishment. This is before you had any of the shutdown orders. And the answer was an employer could tell an employee, because there was no evidence at that point in time, no, you can't wear masks because of our image, et cetera. I actually think in a month, I'd go the other way. I think there's an image right now that if your carry-out restaurant or delivery is not masking employees or gloving them when they are bringing deliveries out to the curb, I think you run the risk of it backfiring to some extent, both with the public and with the employees. So I'm not giving you a legal answer, but if I had my druthers and somebody called me or I owned a restaurant right now, I would be providing masks to my employees to wear during the workday while they're working with each other and when they're interacting with the public. I would, whether or not it's mandated or not in Delaware, I think we're going to see that. And I'm reading the trades, et cetera. What they're now talking about in the future for restaurants is that all menus are going to become paper for a while, and they're going to get discarded as soon as a customer uses them. That wait staff is going to be wearing gloves that are going to be changed. So, you might want to get ahead of that and start that now. But in terms of the PPE issue, I would really strongly suggest that you provide masks to your employees that they can wear during the workday, both interacting with each other and interacting with the public. So,
and if I could just jump in, Gary, I think all of that is great advice. The guidance for the use of face coverings put out by the Delaware Health and Social Services Division of Public Health specifically talks about cloth face covering, not N95 masks or masks that we think about for healthcare workers. We're supposed to be saving those for healthcare workers, right? What we're talking about, what New Jersey said and what New York said, is a cloth face covering that can be washed, right? And this is, remember, this is for, it's not for our protection, right? It's for the protection of individuals who are coming into contact with it, so that for those individuals who are not exhibiting any symptoms or, any sort of droplets, that we're not getting them on anybody. It's for the spread. So ultimately, if we're saying, hey, we need to provide masks, it really is just some sort of covering over the face. Think of it more akin to a uniform issue, right? Like, we're really just providing something that covers the face when you're interacting with a customer that then can be washed and worn again. I mean, that's really what I'm hearing and seeing. What Delaware's Health and Social Services is saying is that, look, if you go out, we're recommending that you put something over your face. And that's to reduce the spread of illness. And I think that's what we're going to see. That's what New Jersey and New York have done already.
Should be no different than a hairnet or a baseball cap or even a beard snood.
Yeah, I'm following a lot of, so I'm on a call every week with my counterparts all over the country and in the Northeast, and there is a supply chain issue, right? So whatever kind of face coverings, the thermometers, so that's sort of, there's workplace realities about what's available to the industry right now. And that with an industry that is in financial crisis mode, what is the regulations or the laws going to be to force us to provide it? I don't know that yet. This is something that's all new. So, and we're going to try to influence it on the side of our industry as best we can. So I think at this point, we've taken everybody's time up too much. You guys are great. I would ask everybody to send us your questions. We'll get them as quickly as we can to Dena and Gary, and we'll answer to the best that we can and they can in simple manners. But if you feel you need legal counsel, I would strongly urge you to use Dena or Gary, because I think they're terrific. So at this, I want to say goodbye for now, and thank everybody for the call today.
Thank
and
you,
again,
everyone.
thanks Dena, thanks Gary, appreciate it.
Thank you.
Bye-bye.